Hello, friends. Welcome to the National Constitution Center and to today's convening of America's Town Hall. I am Jeffrey Rosen, the president and CEO of this wonderful institution. And before we begin, let's inspire ourselves, as always, for the learning ahead by reciting together the Constitution Center's mission statement. Here we go. The National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution among the American people on a nonpartisan basis. Wonderful. I want to share with you some wonderful programs that are coming up. On November 9th, we will be exploring the history of Black women's suffrage in America. On November 19th, we'll talk about the influence of Indigenous people on the Constitution. November 22nd, we've got a great program on executive power, a Lincoln program at the end of the month, and much more. Check them all out at constitutioncenter.org/debate. We'll be taking questions throughout the conversation, so please put them in the Q&A box and I will introduce them as best I can. And now it is a pleasure to introduce our great panelists for today. Wilfred Codrington III is an assistant professor of law at Brooklyn Law School and a Brennan Center fellow. He's written many scholarly articles and opinion pieces, and we're here today to discuss his new book, which is just out, The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union. And Charles Kesler is senior fellow at the Claremont Institute, editor of the Claremont Review of Books, host of the Claremont's American Mind series, and Dengler Dykema, distinguished professor of government at Claremont McKenna College. His newest book, which he'll discuss today, is Crisis of the Two Constitutions, The Rise, Decline, and Recovery of American Greatness. It's such a pleasure to welcome you, Wilfred Codrington and Charles Kesler. Your two books are fascinating because they're both about constitutional history and how we should think about the present, although they approach it from different perspectives. So I want to begin just by inviting each of you to put your important arguments on the table. And Professor Codrington, if we can begin with you, at the end of your book, you identify 5 factors that have coincided with increased interest in the Article 5 amendment process over American history, which include discontent over Supreme Court decisions, transformational social change, the upheavals of war and other crises, policy experimentation in the states, and extreme political polarization. There's a lot there, but tell us how those 5 factors tend to explain the big movements of constitutional change around the time of the founding, the Civil War, and the Progressive Era, and how they may apply today.
Yes, well, thank you for having me back, Jeff. It's great to be here, and thanks to the staff of the National Constitution Center for putting on this and many wonderful programs. And so I think you did a great job of just laying out the 5 things that we see as patterns or catalysts for constitutional change, and specifically for formal constitutional change. That's your textual change to the Constitution through Article 5, which is the amending clause. And so these catalysts are just these combination of things that present themselves, these situations, right in the lead up to or during major amending periods. So one that you mentioned is Supreme Court decisions, controversial, unpopular ones. And I've written a piece actually recently in The Atlantic explaining these a little bit more concisely than the book does. But one of those things is we see that, and it has the possibility of opening up the Constitution for amendment, because as we know, whatever the Supreme Court says on the Constitution is the last word. Or so we can test that in our book. What the people say is actually the last word, and they do that by amending the Constitution. So we saw that in the past before with decisions like the Dred Scott decision, which sort of led to the Civil War, or one of the important events that led to the Civil War. In the Progressive Era, there was Pollock versus Farmer Loans Trust, which the Supreme Court said that Congress had no power to impose a federal income tax. And we amended the Constitution, adding the 16th Amendment to say, yes, actually we do. And that was an important amendment because it brought us into modernity, enabling us to finance complex government operations. We saw it again in the civil rights era with Oregon versus Mitchell. And that was a case where the Supreme Court said the Congress doesn't have the power to lower the voting age to 18. And that's what we did. We amended the Constitution in the 1970s to lower the voting age. So that's a big one. And I say that that's a big one because you see them in every amending period, and they have the tendency to open up an entire period for amendment. But there are others. So there's political experimentation in the states. There's foment, sort of agitation, trying to experiment with things that states can do, but the Constitution doesn't necessarily allow or permit or accommodate. So we know, for example, abolition was a movement that started in the states before we got the 13th Amendment. We know that suffrage was happening in the states before we got the 19th Amendment. We know a lot of things that we've gotten in the Constitution have been things that the states have started and the Constitution shored up. And the other, as you said, transformation, social change. We see this often with sort of new demographics and innovation in technology and a changing economy. You notice you mentioned intense political polarization. We're in a period right now of an intense political polarization. We saw those before. At one point during the Civil War, it led to a complete dissolution of the war, where you had radical Republicans sort of running the agenda for constitutional reform. But it also happened during the Progressive era, where you had this sort of coalition, this realignment of parties in power, which allowed amendments to come through. And the last one is sort of a sense of insecurity. And this is something that happens during periods of war, during economic downturns and recession, during a pandemic. You know, this is not the only pandemic where amending the Constitution could possibly on the minds of Americans. You know, we had the pandemic, which was occurring when prohibition and suffrage was sort of the movements of the day. And so this is what we try to do, look at the different periods of history, the 4 different periods of constitutional change, and distill those factors, those patterns, those catalysts that have fomented and facilitated constitutional change.
Thank you so much for distilling the arguments so clearly. Charles Kesler, in your new book, The Crisis of the Two Constitutions, you contrast 2 constitutions, which you said have been at loggerheads with each other throughout American history. One is the Founders' Constitution of 1787, grounded in natural rights and the practical wisdom of the Declaration of Independence. And the second is the Progressive Constitution, which you say is based not on equal individual rights or on changing natural rights, but on rights that travel in groups and vary with the historical moment. Tell us more about your understanding of the Founders' Constitution and the Progressive Constitution.
Okay, thank you, Jeff, and thanks also to the National Constitution Center for this kind invitation. It's good to see you again. It's good to meet Professor Codrington, and I've looked at your book. I haven't read it all, but I intend to. It looks very interesting and very well done from the parts I've seen. I argue that if you look at American constitutional history at large, you can see sort of 2 major divisions. Up to, let's say, the beginning of the Progressive era, you have the practical, legal, and philosophical, you might say, dominance of the Founders' Constitution and its moral and political and intellectual presuppositions. And beginning with the Progressive era, you have a sort of new American political science that Woodrow Wilson was a very important part of, Herbert Crowley, Teddy Roosevelt in his own way. He was not a political scientist as Wilson was, but he was up to date on the latest political science in America. And the new political science regarded itself essentially as post-constitutional. They weren't exactly anti-constitutional. They were not against the 1787 Constitution as amended, which they thought was fine for its time. It was the very best in 18th century constitutionalism. But they thought that the world had changed and political science had changed, the needs of America had changed. And so you needed a looser, more evolutionary form of constitutional architecture. And this was what Wilson and many of the other progressives called the living Constitution. When we hear about the living Constitution today, it's usually in connection with a Supreme Court nomination, when there's a debate about what is the judicial philosophy of the nominee. But when Wilson and the originators of this concept used the term, they didn't confine it to the judiciary. They were talking about a way of approaching politics at large: executive power, legislative power, judicial power, and the new forms of mixed power that came to be called, the bureaucracy or the administrative state in Washington, centered in Washington, which combined legislative, executive, and judicial power in novel ways. They did this with the best of intentions. They intended to solve America's new social problems, its burgeoning social disorders, whether it was new large-scale corporations and the problems of big cities, of large numbers of immigrants coming all at once from Southern and Eastern Europe and so forth. They had an array of social problems which were in some sense new, which they thought you needed in a way a kind of new constitutional arrangement to deal with. But today we're suffering in a way from the collision of these two tectonic plates: the old Constitution, which was purposely designed to be hard to amend, and the new, much more open-ended Constitution. And I think if you, are you hearing that phone call? Sorry, I am.
Oh, no trouble. Although we can, it's the administrative state calling. Let's see. There we go. You're back. Sorry, you were just talking about how this new vision of a more flexible vision of executive and congressional power required new structures.
Yes. Yes, and that's right. And it required precisely the kind of mixture of powers that Madison was very much against, and that the authors of the Federalist Papers thought would really be tyrannical, or would eventually become somewhat despotic. And so we have a kind of somewhat incoherent constitutional structure now, because we have this informal Darwinian kind of constitution from the progressive era overlying and competing in a way with the formal constitutional structures of the old Constitution. One is, so to speak, more conservative. The progressive Constitution is obviously more liberal. And part of the bitterness and the lack of moderation in American politics today, I think, comes because we have we have two constitutions for one nation. And that sets up a kind of fundamental political conflict that is very hard to manage and very hard to moderate.
Thank you very much for that, and for summing up your argument so clearly. Because both of you have distilled such clear arguments, I'd love to ask each of you to react to the other. So, Wilfred, if I may, Charles says, as you just heard, that the progressive Constitution regarded itself as post-constitutional. It needed looser forms of constitutional structure, new ways of looking at executive, congressional, and administrative power. And this new post-constitutional vision competes with the framers' Constitution and is responsible for much of our clashes in America today. Do you agree or disagree with that as a historical and narrative statement?
Yeah, so I think that's interesting. I haven't really, I've read your book as well, so thank you. I wouldn't call the modern sort of view of constitutionalism post-constitutional. What I would say is that, and what we argue in the book, are there these periods, and it's interesting because Professor Kesler used the word tectonic plates. We also use the word tectonic plates as a metaphor for what's going on. But there are these periods where you have these sort of situations, these factors, these elements out there that are sort of rubbing up against each other and create the sort of potential and the opportunity for constitutional renewal. And so Professor Kesler said that it's sort of a dichotomy, these two constitutions, but we look at it very much in four different ways. So I wouldn't say that there's this old constitution. The old original constitution, as we know, was what was adopted in the 18th century, but at each generation, we added to that. And sometimes we actually had to subtract from it, right? So the first generation, the big thing we had to do from the framers' constitution was to subtract slavery and racial subjugation. And we did that in a big way. And, you know, and that also repudiated this sort of idea of Madison's original framework, because with the 14th Amendment, we know that we had this reorientation of power. We had this rebalancing of what federalism looks like, where we now put more power into a vigorous federal government and took power and put controls over the states so they couldn't slip back up into this state of slavery and subjugation. So that was the first sort of overlay on the framers' constitution. The second overlay, and I think this is where Professor Kesler picks up, he says this is the more modern version, was the progressive era. And the progressive era was largely a product of these dynamic social movements. So your movement for temperance and your movement for suffrage and your and sort of populism going on, and also pushing back against corporate abuse and political and public corruption, right? And so, yes, what they tried to do is to push back on this. And one of the ways they did that was through the 17th Amendment. So that way it gave the people the power to choose their senators, as opposed to allowing what were then often corrupt state legislators to choose the senators. And as I said, they pushed back with the prohibition, which was failed, but meant to be this sort of novel purifying force in politics, and suffrage, including women into the American people, finally. And then there was also the sort of development of the administrative state that we look at as sort of a failed era for formal constitutional reform, but it did change the Constitution nevertheless. So the Constitution is changing even when we don't change it directly. And this happens again through Supreme Court decisions, through big politics. The New Deal era was one of those big sort of informal amending periods. And then we get to the civil rights era again. And that again, smaller amendments, formal at least. But a lot of the energy there was also to sort of repudiate some of the failures of the past eras of the Constitution. And this one really was to bring to the surface, again, the promises of the Reconstruction era, which had been ignored for 8-9 decades when Jim Crow was the law of the land in parts of the country. And so, yes, there is this sort of base of the sort of Madisonian framework of the Constitution that we got in the 18th century. But with every big amending period, we added to that, and to make it a more democratic, more promising, more inclusive document that was better suited to govern the American people at the time.
Thank you very much for that. And thank you for identifying that important point that, as you say, progressives viewed the New Deal as an informal moment of constitutional transformation, even though it didn't culminate in a formal amendment, and conservatives dispute that the New Deal was a legitimate act of constitutional amendment because there was no formal one, and much of the battle over the legitimacy of the administrative state focuses on that question. Charles Kesler, if I may ask you to respond not to that point, but to Wilfred Codrington's historical claim that interest in Article 5 amendments over time has coincided with periods that include discontent over Supreme Court decisions, transformational social change, the upheavals of war, policy experimentation in the states, and extreme political polarization, just as a narrative and historical statement. Do you agree or disagree with that account?
I think that's a very good and accurate account. I don't really have any disagreements with it. I think it is interesting, though, that, well, one thing that is very nice about his book is that Professor Codrington notices precisely the way that the emergence of these amendments over time, and often in groups of them all at once or in a very close proximity to each other, is tied into the rhythms of American politics. And it's in a way a kind of tribute, maybe a backhanded one, to the framers' wisdom in making it difficult to amend the Constitution, so that when you do, you sort of get pent up political and social forces. They have to chew on it a while and figure out what amendments are really needed and which ones can we find a supermajority of the country and the Congress to support, so that it's a kind of combination of a willingness to change and openness to change in the Constitution itself. The framers didn't, after all, think the Constitution was perfect and should be unchangeable. Article 5 is in the Constitution precisely because they foresaw that defects would need to be corrected, would need to be discovered and corrected, and that conditions would change, and that some form of very deliberate and well-considered and occasional constitutional amendment would be necessary. They were very realistic about that, and his book nicely shows how, you know, in episode after episode, you get these well considered and in a way mutually supporting bursts of amendments to be added to the Constitution. But the interesting thing, I would say, is how we, in the 20th century, those bursts of amendments have stopped, and where you would have expected another couple of amendments to be added, precisely in the New Deal, as Professor Codrington was saying, you get, you don't get one. You get what FDR calls the second Bill of Rights. I mean, he had really worked this out. He had a list of what would have been, presumably, constitutional amendments in an earlier day, a bunch of them that he would have offered and probably been able to pass at least many of them through his heavily democratic Congresses in those days, and through this, and perhaps through the states as well. He'd never offered them as formal constitutional amendments. And that, I think, is very revealing, because it shows in a way that if you have a living Constitution, you don't need to go through the complexities of the formal amendment process. The idea is that the real and increasingly relevant Constitution is a very flexible one, an unwritten one that can change as circumstances change. And you don't need formal amendments to an informal Constitution, which is the real distribution of political power at any given time in American politics. So whereas the founders thought the Constitution had to be above normal politics, had to float above statute law in order to keep politics within certain moral and constitutional boundaries, the new understanding really is that it's not government that sets, it's not the Constitution that sets the limits on government. It's in a way government that sets the parameters of the Constitution. And you don't need formal amendments to an informal Constitution. And so the second Bill of Rights, which was perfectly set up to add to the enumerated amendments, gets realized by the addition of programs to the federal government. You get, the right to healthcare, the right to a job, all of these new socioeconomic rights in the second Bill of Rights are fulfilled by federal government programs, budget items, not by a change in the constitutional writ per se. And I think that shows you we're in a different era constitutionally than any time in the 19th century or in the first, say, 2 decades of the 20th century.
Thank you so much for that. And that leads me to ask you, Wilfred Codrington, are we in a different stage than we were at the end of the 19th century? You end your book by saying that this looks a lot like the Gilded Age, a time when politics were divided between that era's 1% and farmers and exploited laborers, and the sense of urgency gave rise to a push for constitutional reform. It's reasonable to anticipate that this time of partisan gridlock, you say, will someday give way to a new governing consensus. Only time will tell whether the American people will be inspired, as previous generations have been, to form the political coalitions needed to foster the next wave of constitutional change. I mean, the obvious question, of course, is there doesn't seem to be any chance of a meaningful constitutional consensus on the horizon that could lead to a new amendment. Even the amendments about which there seemed to be the most consensus as a policy matter, like term limits for Supreme Court justices, which our Constitution drafting project at the Constitution Center found the conservative and progressive teams agreeing about, seem to have no chance of passing because of the difficulty of getting stuff through, Congress to be proposed or the states to be ratified. So the question is, do you believe that we will see constitutional amendments following the factors that you say at every time previously in American history have led to formal constitutional amendments in the past?
Yeah, so I just want to make it clear that, I think some people tend to look at history and think that the future is a foregone conclusion. And that's not the position that we take. What we do is try to show the similarities that have existed in other times leading up to constitutional change and say that, hey, this is not reason to be despondent. This is not reason to lose all hope. Know that in periods that have been far more difficult than this, the Civil War was far more difficult than this. The sort of early founding period where we could have lost the Constitution without constitutional amendments, far more difficult than this. And yes, it's pretty bad out there, I think. People are understandably frustrated with the conditions today, the social conditions, the political conditions. And so what we try to do is to say, but we've been here before. And so it's not a foregone conclusion that we'll take the sort of seize the mantle here and push for that change. But I do think some of the things we're seeing today are eerily reminiscent of past periods. So I spoke about the sort of social movements that were going on during the progressive era. Well, we're seeing robust social movements today as well. And not all of them have constitutional change on their mind. We've seen the sort of nation facing its really reckoning with anti-Black politics and anti-Black discrimination. And you've seen the Black Lives Matter movement come up, and that is a robust movement. We saw in the wake of the 2008 recession that you had the Occupy Wall Street movement come about and sort of highlight the disparities between the 99 and the 1%. You've seen the sort of robust women's movement with the marches like that now are almost common. Taking to the streets and to the mall and sort of demanding equality. And that one, I would say, is very much aligned with a push for a constitutional amendment, specifically the Equal Rights Amendment, which failed when it was initially passed by Congress and sent to the states. So we're seeing that. We're seeing this sort of wide chasm between the haves and the have-nots. We're seeing political polarization and swings in control of the government. In the lead up to the progressive era, in the 1876 and again in 1888, you had two times where you had the Electoral College misfire, not dissimilar to what we got twice in 2 decades, in 2000 and 2016. So I think it is difficult. But the goal of this book is to show that it has always been difficult. It has always been perceived as difficult. And then when things seemed impossible, people who had been laying the ground for decades actually found an opening where they could turn those projects that makes the country better and more democratic and more governable, turn those projects into something real and changing the Constitution along the way.
Thank you very much indeed for that. Charles Kesler, has the Constitution become harder to amend than the framers anticipated. I mentioned a few amendments about which there seems to be broad conservative and liberal agreement. The possible term limits for Supreme Court justices is one. The other thing that our Constitution drafting teams agreed on, the conservatives and progressives agreed on an electoral college amendment that would have a national popular vote. And indeed, such an amendment came within a few votes in the Senate of being proposed in 1971 and was endorsed by both political parties, but was thwarted just by a couple of Southern senators. So do you think there's a case that it's now impossible to get amendments about topics for which there's broad bipartisan consensus, or is this the way the Constitution is supposed to work and has always worked in terms of the difficulty of formal amendments?
Well, you you have to come to some consensus before you can have an amendment. I mean, you need, classically 2/3 of each House of Congress and 3/4 of the states to agree to it. And that's a consensus. But right now we're very far from such a consensus, and things are complicated because the standards by which you evaluate constitutionality differ basically from the older Constitution to the modern progressives Constitution. We're really talking about competing constitutions rather than simply ways to interpret the same written document. And that's why, I mean, after all, the 13th, 14th, and 15th Amendments, which Professor Codrington rightly pointed to as perhaps the most important of all the amendments after the Bill of Rights, and maybe even including the Bill of Rights to a certain extent, in our constitutional history, that consensus was only possible after the Civil War, as a result of the Civil War. One side had to win, and the other side had to lose, profoundly, in order to create the conditions of political consensus that enabled the 13th, 14th, and especially the 15th Amendment to pass. And then those amendments had to run a gauntlet of judicial interpretation, which in some ways was the last gasp of the pre-Civil War Amendment Constitution coming to life again. So I think Professor Codrington and I might disagree about how to understand those amendments, the 13th, 14th, and 15th. I would understand them as basically, I think Lincoln and the party of Lincoln would have understood them to be really fulfillments of the anti-slavery premises of the Declaration of Independence and the Constitution, rather than a repudiation of the original Constitution. And that's a very big question, highly controverted still today. It was controversial in the 1860s. It's certainly controversial today. But you can learn a lot from looking at the terms of that controversy. But I think today, the case of the ERA is interesting. Here is an amendment which fit the bill from Professor Codrington's point of view. It should have been added to the Constitution in the 1970s instead of being stopped just short of being added to it. It was inclusive, it was progressive, it was the things which Professor Codrington, I think, regards as good constitutionally. But it failed the test of popular consent. It couldn't get the 3/4 of the states that it needed in time. The last amendment to be added to our Constitution, the 27th Amendment, was initially proposed by James Madison. It was one of the original group of amendments out of which came the Bill of Rights in the first Congress of the United States. It took 200 plus years to get it added to the Constitution. That is a remarkable occurrence, but it does suggest that we've sort of run out of contemporary amendments that can run that can survive the process, because there is no sufficient consensus, I think, for them. So I would be somewhat pessimistic, to answer your question, that any of the amendments that the NCC has looked at is probably likely to be added anytime soon. Although the judicial one of them all, I think, might have the best chance. But that it's so caught up in the question of which way the court is going to go in the next couple of terms that, I think is too controversial to make any headway.
Thank you for that pessimistic prediction, that cool-eyed, and you may well be right. But we will, at least in our state of nature or state of Zoom, have a wonderful test of the ability of the progressives and conservatives and libertarians to agree when they all reconvene at the NCC and virtually in just a few months, and see if they can agree on the words of any amendments. Wilfred, Codrington, we've got a bunch of questions in the chat about this question of the administrative state. Does one of these visions of the Constitution parallel what conservatives call the Constitution in exile, says David Silverson. And indeed, the Constitution in exile was a phrase used by Judge Doug Ginsburg, a friend of the NCC, to describe the need to resurrect limitations on the powers of the administrative state, such as the non-delegation doctrine and the limits on the commerce power that have been dormant since the New Deal. This is, as you heard Charles Kesler say, Wilfred Codrington, a very big issue for conservatives who think that the whole New Deal was illegitimate because it didn't have a formal constitutional amendment. And there's some real constituency on the Supreme Court for rolling it back. How does this particular battle over the scope of the administrative state and its constitutional legitimacy fit into your framework? And to what degree is the expansion of the current administrative state, in your view, supported by popular movements among progressives?
Great, yeah, and so I just want to quickly respond just to give a little bit more of a hopeful look on this all. I do think that there are amendments, if we could get our sort of political house in order, that the American people could rally behind. So you mentioned the Electoral College. The Electoral College is one of the two most proposed ideas for amending the Constitution. As you noted, it came very, very close to becoming an amendment in the 1970s, except for a stalwart Southern segregationist, a filibuster to stop it. It had 80% of the American people backing of it. Right now, we talked about, and actually it's interesting because Dr. Kesler talks about what might promote a crisis, and he mentions the Supreme Court decisions as well. So we do have some more of an overlap there, and I think that one of those decisions we see that is universally reviled is Citizens United, and I think that unites progressives and conservatives alike. You know, there's a smaller bandwidth of people who think that corporations should have unlimited sort of financial power and dominance and say in our elections. And then you noted the Supreme Court decision, or the term limits on the Supreme Court. And I do think that that's gained some traction, though there are a number of different proposals for restructuring it and thinking about the Supreme Court. So I think that there's more optimism there. Hopefully we can kind of get to that. But in terms of the New Deal, I think that, you know, it fits and it doesn't fit in our framework. And we sort of think about the four big periods of amending the Constitution. One was the founding era, largely the Bill of Rights in 11 and 12, Reconstruction era, the Progressive era, and the Civil Rights era. And then in the sort of this middle state, you get a few little staccato amendments, which is totally rare in constitutional history. And at that same time, you're also getting that informal change with FDR. So the idea there is that, you know, FDR certainly, as Dr. Kesler mentioned, had overwhelming power. So maybe he could have done something about it formally, but it seemed like he was confused as to what the actual proposed amendments might say and what they might do. He was a little bit worried that the Supreme Court that would ultimately have to interpret amendments would sort of continue along the Lochner era and the conservative sort of line of not giving power to the words of the Constitution. And so he kind of just took his chances with sort of popular democracy behind him and pushing for a more robust state to counteract what was the critical issue at the time, the Great Depression, but then into the war, right? And so, you know, like that, and that was a fateful decision. There is a constitutional theorist, Stephen Griffin, I believe he's at Tulane, and he just says, maybe there would be more consensus on the power and the legitimacy of the administration and the New Deal if we were to have actually ratified the child labor amendment, which was symbolic of that period, what was going on, because the court was saying that there was no power to regulate child labor. And so, yes, we got to this period where we had this revolution that could have been a constitutional revolution in the formal sense. And what we ended up with is the sort of debated administrative state, which we're still contesting today. What are the bounds of the sort of administrative and regulatory apparatus and the programs like Social Security and other things that sort of extend from that? And we're going to continue to have that debate. My hope is that what we can do is sort of terminate some of this debate with some amendments that will sort of solidify our understanding. That would be fantastic. But until then, we're going to continue having this debate with conservatives and progressives, attributing certain levels of legitimacy and illegitimacy to that period.
Thank you so much for that. Charles Kesler, would the conservative objections to the New Deal administrative state drop away if there had been a formal amendment? After all, FDR, considered one, and it might just as well have passed as not. Or is this a much more fundamental disagreement about the scope of federal power? And to that degree, how do you talk about different disagreements among conservatives? We know that conservative presidents have embraced rule by executive order and big government just as enthusiastically as liberal presidents have. So to what degree does that reality coincide with the debate that's going on the Supreme Court?
Well, that's a good question. There are disagreements among conservatives, among originalists. People who call themselves adherents to a jurisprudence of original intent don't all, of course, agree about that. And there are some very interesting schisms, you might say, on the right about how to interpret that. If you take the issue, for example, of affirmative action, this is a very interesting one on the right, I think, because even though Reagan campaigned against it and had the chance to sign an executive order or to take other more substantive legislative action to try to cut it back or rein it in or constitutionalize it, you might say, he failed. He didn't do it. He didn't really try it. And conservatives have been divided about it and what to do about it for a long time since. But I think the general, you mentioned Doug Ginsburg and the Constitution in Exile notion, and I think that's very relevant to the discussion, because from the old Constitution's point of view, or at least the conservative version of the old Constitution, what we have today is that the Congress and the administrative state are sitting as a kind of permanent constitutional convention, able to, you don't pass the ERA, but what legislative proposal has been turned down or what regulatory proposal has been turned down because there isn't an ERA in the Congress, in the Constitution, none. Basically, the administrative state goes ahead and tries things which would normally have been stopped by the lack of a constitutional provision to support them. The existing separation of powers is a far secondary consideration to wanting to get something done by the administrative state and by the mostly the progressive coalitions that have invented the administrative state and used it for a large percentage of their lawmaking and rulemaking for many decades now. That, I think, isn't going to go away. And it does argue against going through all of the trouble of a formal constitutional amendment process. When you can basically find a way to get what you want without having to go through the constitutional amendment process, why go through it? The condition is different in California, where, by the way, we talk about tectonic plates all the time with a very different actual point in mind. But in California, it's very easy to amend the California Constitution. We do it all the time. We do it every 2 years, basically. So there have been something like 500 amendments to the California State Constitution, the second California State Constitution, the progressive one, the one that Hiram Johnson as governor gave us. And the result is that the Constitution of California is a book. It's book length. I mean, it's about, depending on the size of the type, 250 pages, or I've seen it in a 500-page edition. It's a small book. And it doesn't have anything like the moral authority that the 4,500 words of the Constitution, and now a little bit longer, of course, because of the amendments, has. And that was one of the reasons Madison wanted to make it difficult to amend, so that it would not be similar to statute law. It would be a higher law, a more fundamental law to control statute law and even to control popular majorities to some extent in the future. I think that in the current situation where we don't formally consider amendments very often because we don't consider the formal Constitution all that relevant to what actually government can do and will do, we're in danger of losing some of the moral high ground, some of the veneration of the Constitution that Madison and many others talked about as essential to keeping constitutional government as something different from the government that floating, ever-changing popular majorities or legislative majorities can enact. And that, I think, would be the comeback from, as it were, the first Constitution to the second Constitution. That when the modern day Constitution is essentially itself a product of the legislature or of the bureaucracy, it no longer has any majesty. It no longer has any moral weight, or at least not the same kind of majesty and moral weight that Madison and Hamilton and Washington thought it needed in a very robust democratic political regime.
Thank you very much for that. Wilfred Codrington, Charles Kesler just suggested that the administrative state and affirmative action are the product of the legislature and of the bureaucracy, not of the Constitution. And I want to ask you about affirmative action, abortion, and gun rights. Next week, the Supreme Court is going to hear both the most important Second Amendment case of the term, as well as the Texas abortion challenge on an expedited basis. Conservatives say that abortion decisions and affirmative action decisions are reading into the Constitution rights that don't exist and thwarting the will of the people. Progressives counter that it's the court that is imposing its own views and uprooting precedents and striking down laws that are well-rooted in the Constitution. How does this debate, which is obviously the central one on the court this term, fit into your account of constitutional history, mostly coming from the bottom up?
Yeah, so I don't think that the point of the book should be that there's not sort of rule by elite institutions. That's the nature of a government. But what I do believe is that much of the Constitution was written in a way to have a little bit of play in the joints, to allow for government and the people to actually express themselves and exercise themselves and in fact govern themselves, right? So Dr. Kesler talked about the Constitution being rather short. It is rather short and rather long-standing. And I think it's done a pretty good job, but at various points, we saw that it didn't do the job well enough. So we added 40% more of the Constitution after the original Constitution was ratified. And that, of course, is through the 27 amendments. And so the things that are happening at the Supreme Court, they're going to happen at the Supreme Court. This is what the sort of idea was. We're supposed to have an independent judiciary that carefully considers the facts and the legal questions before them, those that are sort of governing or sort of agitating people. And you mentioned a few of them that are going to be hot button issues, perhaps affirmative action, definitely abortion in a couple different modes, a couple different cases, guns, right? And we have this sort of independent body that's supposed to make these decisions as to what the Constitution contemplates and what it doesn't. We've had that happen throughout history. This is the point of McCulloch v. Maryland back in the 1800s, when Chief Justice Marshall said, hey, it may not specifically say in the Constitution that the Congress can charter a bank, but Congress has broad powers about sort of funding armies and regulating commerce in the economy. That is in the Constitution. And so we have to sort of be a little flexible what those means, because we don't want to have a California type constitution that spans pages and pages and pages and tomes in a book. What we want is something that we can work with, and when we can't work with, we amend it. But that gives the Supreme Court some ability to make those interpretations on those important decisions. And as I said, when the Supreme Court gets it chiefly wrong, it has opened up paths for amendment in the past. And so perhaps that's what we'll be facing again. But these hot button issues, I think, gives the Supreme Court more opportunity to sort of step in it, if you will, and motivate people from the bottom to push for amendments, motivate them and enforce them to have governing and elite institutions to implement them through constitutional amendment.
Thank you so much for that. Charles Kesler, I'm going to ask you about abortion and guns and affirmative action, obviously the most controversial constitutional issues today. To vastly oversimplify, conservatives some claim that overturning Roe, striking down affirmative action, and ensuring that the Second Amendment is not a second-class right is a way of resurrecting the original understanding of the Constitution. Critics counter, there are originalist arguments against each of those positions, and the conservatives are just imposing their policy preference through the court. How do you look at the debate?
Well, I don't know anyone who thinks that Roe v. Wade was an excellent piece of judicial reasoning. I mean, Ruth Bader Ginsburg, many people, very intelligent law professors on the left have argued for many decades that this was a contrived opinion, hard to justify, if not impossible to justify by normal legal reasoning. And so because what we refer to as our abortion law is really not a law, it's basically the writ of the Supreme Court from Roe v. Wade and in the ensuing cases that supported Roe over the years. So it would be nice from the point of view of the original Constitution that whatever the abortion regime is, it ought to be legal, that is made by legislatures and approved by the people in some way, whether that requires a constitutional amendment, which is sort of the maximum case, or just 50 state legislatures determining what they regard as optional or best in their state on the question of abortion. Gun rights, I think, is also a case where is a slightly different case, where you do have a constitutional amendment, you have constitutional writ, and you can have a good argument back and forth about what the original meaning of it was. Although to me, it's for a couple of decades now, the scholarship on the part of the so to speak, the larger gun rights argument as an individual right seems to have won the day. That seems to me, if that debate isn't over, it has certainly been going the conservatives' way for a long time, or at least a couple of decades. And I don't think that given the Second Amendment, if you want to circumscribe gun rights drastically, then you probably ought to amend the Second Amendment. You ought to do it in an above board sort of way, which will never get anywhere, of course. But the Democratic Party platform in 2016, and as far as I know in 2020 as well, although I haven't looked, called for amending the First Amendment to exclude Citizens United in cases like Citizens United, campaign finance cases, to indicate that speech and money are not the same thing and don't count as the same thing in constitutional in a constitutional balance, which is in its own way quite amazing. I mean, who would have thought that amending the First Amendment would be the official position of a modern American political party, amending it to circumscribe the coverage of the First Amendment, of political speech in terms of political ads and so forth, bought, it is true, by money. So this is going to be interesting because it may in fact vindicate at least of Professor Codrington's point, which is if the court goes in a conservative direction on one or two or three of these issues, certainly pressures to override the court, either by packing it or by amending the Constitution to obviate the court's decision, will increase. And I think if that's his prediction, which I think it probably would be, I think that's right as far as it goes. Although I remain skeptical that it will increase the pressure enough to actually result in anything constitutionally.
Thank you so much for that. Well, it's time for closing thoughts in this very rich discussion. And I'll just ask for some brief ones so we can end on time as we always do. And the question that I'm going to ask each of you is this. If you had to identify a single constitutional amendment to increase the guardrails of democracy, what would it be? The Constitution Center has an initiative to try to bring together progressives, libertarians, and conservatives to identify potential reforms to increase the guardrails of democracy that have been eroded by polarization and technology. And I'm eager for your thoughts about what your amendment would be. And the first thought is to Professor Codrington.
Thank you, Jeff, for that question. And thanks for the discussion. And thank you, Charles, for being on the other end of this discussion with me. So as I noted, this is probably going to be very hard because, as I noted, our theory is that constitutional amendments tend to come in clusters. So I'm kind of thinking about it in clusters. But I would say if I had to choose, I would go with something that's going to bolster democracy. And that's either going to be a right to vote amendment. As you know, our Constitution doesn't sort of positively guarantee a right to vote, but we have a robust anti-discrimination framework in our Constitution that prohibits the right to prohibits discrimination in voting on the basis of race and sex and wealth and the like. And so we don't have a robust right to vote. And if we look at what some states in the country have in their constitution, they look at their robust right to vote for free and fair elections to have gotten rid of political gerrymandering, for example, and to overturn laws relating to restrictive voting ID measures, for example. So I would add that in there, or I might go with the Electoral College. And the Electoral College, again, as I said, is one of the most popular. We saw what has happened with the Electoral College recently. It is problematic. Twice in two decades, we've gotten Electoral College misfires that have given us what have been pretty poorly prepared presidents. And it also sort of gave us this opportunity at the end of an election for an insurrection to take place, this long period where they're contesting the results of the Electoral College outcome and sort of all the things that came with that in terms of starting an insurrection and legal shenanigans about how you sort of have a coup, those sorts of things. I do believe fundamentally that if we were to just have a popular vote in a normal transition, like most democracies do, we would not have been facing that sort of situation. So something that is definitely going to make our democracy more robust, more participatory, more inclusionary, and sort of reflect the real will of the people more. I think those are the ideas that the original framers had in mind when they said that we're supposed to amend the Constitution seldomly, but for big ideas, for things that are lacking.
Thank you very much indeed for that. And Charles Kesler, the last word is to you. If you had to identify a single constitutional amendment to protect the guardrails of our democratic republic, what would it be?
Well, it would not be to abolish the Electoral College. I'm a defender of the Electoral College. I think our problems really don't have much to do with it. That is, our problems in our elections. I would say some version. I mean, one doesn't have to have amendments. You know, it's not a moral commandment that one should be in favor of amendments. But if one is discussing the subject, I think an amendment that would, I'm not sure term limits for judges is exactly the right term to use to describe it, but that would spread out the nomination of justices, federal justices, over every president would get perhaps one or two nominations, and so that you would have some greater democratic influence over time on the court, and break up some of the sclerotic power that the court has drawn to itself, both in its liberal phases and in its conservative phases in the modern era. I think that is probably defensible. I also think, something like Prop 209, which we had here in California and which survived an electoral test just in the last election cycle here, to forbid racial discrimination in government hiring and in college admissions and things like that. I think that's advisable, and that sounds like what a classic kind of constitutional amendment should do. But beyond that, I would have to think long and hard about the other proposals of NCC before I would endorse any of them. But I think those two ideas are good, and if one could rescue the Constitution from exile by constitutional amendment, I'd be interested in something that could restrict the power of the administrative state too. I'm not sure exactly that that's possible, and if possible, what the amendment would actually say, but I'd be interested in hearing more about it.
Thank you so much, Wilfred Codrington and Charles Kesler, for a very rich discussion. Thanks for identifying those potential amendments, ranging from a right to vote and electoral college amendment to a term limits and affirmative action amendment. The NCC, of course, endorses none of these. Our role is just to convene people of different points of view, like both of you, for these thoughtful conversations and to explore areas of agreement and disagreement. And that's exactly what both of you have done with your extremely rich and illuminating interventions. Thanks to you, friends, for taking an hour in the middle of your day to learn and grow together. It's so meaningful to convene with you and to live out the exhortation of Justice Brandeis, come let us reason together. And that's exactly what we've been doing during this great hour. Charles Kesler, Wilfred Codrington, thank you so much for joining. Thanks, friends. See you all again soon.